I want to say up front, thank you for all of your contributions to all of the juvenile justice and the Parenting Act bills that we've worked on in the last 4 years at the Judiciary Committee since I've been there. Senator Ashford has been very committed to juvenile justice issues, and last year he just was completely fed up with the violence he was seeing and reading about in Omaha, and wanted to do something major about it, to give all of you more tools, more flexibility to intervene early with these kids who are at risk and their families are at risk. And thank you for all your good work, and I'll talk a bit about LB 800 now. The goal was to address the needs of at-risk youth and allow all of you to get involved earlier and have more diversion-type programming available, alternatives to detention available across the state. And like I said, Senator Ashford and the Judiciary Committee have been very intent on learning about how the juvenile process works and how the process can be made more efficient to help kids get to permanent placements sooner and have their problems addressed earlier. And there were a lot of different goals in LB 800. One of them was to encourage alternatives to detention to be developed. I'll go through this slide, sorry. To encourage more alternatives to detention to be developed, to give probation more authority to intervene before sending children back to court to revoke their probation. And we did the graduated sanctions, put that in statute. I know that probation was working with graduated sanctions before LB 800, but this made it official and codified it. We also put in a provision to allow for civil citations. Now, this is an idea that has come out of Miami-Dade County, and we had a lot of presentations, a lot of discussions about it prior to putting it in LB 800, and it's just a permissive provision for Douglas County right now. As far as I know, nothing is starting yet, but they can take that and run with it if they want to. There were a lot of provisions in LB 800 about truancy intervention, and it continues to be a relevant topic. I get calls about truancy daily almost. I just talked to somebody this morning before I came over here, so we have some provisions about that. Sealing of juvenile records was a major provision. It was a separate bill that was recommended by the Minority Justice Committee, and they spent a lot of time studying this issue. And so we got, I think, a more comprehensive process in place in statute to help children who do make mistakes early in their lives to overcome them and allow them to have a clean record and to proceed to getting jobs, getting scholarships, going to school, and becoming productive citizens. We also put in some money. Senator Ashford found some money to give to the Office of Violence Prevention to distribute for violence intervention programming. And that has, I know there's lots of great programs using that money through the grant process. Okay, now I'll talk more specifically about some of these provisions we put in for diversion, for addressing juvenile offenders who are not a danger to themselves, not a danger to others, who don't really need to be in detention, and who, particularly in Douglas County, are kind of languishing in detention. And through the process, they're there too long, or they're there unnecessarily, and so we wanted to find ways to address that. And that was one of the reasons to put in the civil citation program. We're also trying to phase out the process of sending juvenile status offenders to detention based on a violation of a valid court order. Now, that's part of federal legislation that's going through the process, and so we put that in here early, knowing that we're going to have to do it down the road. And graduated sanction provisions, and we worked with probation and some juvenile probation specialists on that. And I know that they have been using that and that process before LB 800, but this made it official and gives them some more flexibility there. And then we also put some prioritization on the grant money that goes out to counties across the state. We want that money to be used, if at all possible, for finding ways to keep kids out of detention. Creating more alternatives to detention and creating more diversion type programming. And other ways to enhance efficiency, and this might be where a lot of you come in contact with the provisions of LB 800. The timelines for when evaluations are done and then the judges and hearings are held and judges get to make determinations based on those hearings. We wanted to speed that up a bit. The only one we actually put in was for the when evaluations are completed, there has to be a hearing within 10 days of the evaluation being completed. The video conferencing provision was kind of a statewide. I know it's not really a problem in some of the more urban areas of the state, but in rural areas of the state, there's a lot of transporting of juveniles to places for court hearings and conferences. So we wanted to give more flexibility to the courts to use whatever technology they have available. I know there's some challenges for courts who need some more technology to do this. So hopefully when the financial situation gets a little bit better, we'll have some more technology. Now, the elimination of the 3-judge panels was actually one of the most controversial thing that went into this bill. There were a lot of opinions back and forth. There wasn't a real consensus on this, but there were good things about the 3-judge panels and things that were not ideal. So what I heard in the process of writing this bill was the 3-judge panels allowed for a real expedited process, and they allowed for a stay of an order that was, when the judge issued the order that was different from what HHS had recommended, then this 3-judge panel could be assembled and was happening within 60 days, I guess, typically, but it was also a pretty tricky filing process, and there were rules about whether to file for this 3-judge panel or to the Court of Appeals, and so there was some confusion about that, and also a lack of consistency when you have these 3-judge panels assembled from judges all over the state. There wasn't a lot of consistency in the outcomes. So we eliminated that process, and now those appeals would go straight to the Court of Appeals. And the Court of Appeals has their own policy for expediting these cases and getting them, putting them on a high priority for resolution. And so I think, I hear that typically they're handled in the same month that they are filed. Now, you all practice and may know differently from me, but so we hope that'll be a positive change. And then we also put in some language just emphasizing the need for juveniles to be placed in the least restrictive means possible, and least restrictive environment possible. This is something I know you all know and have in mind in all of your actions, but we wanted to put it in writing in as many places as we could. Truancy was a major concern for Senator Ashford. There was, in Douglas County, or in Omaha last year, there was a lot of truancy filings that kind of came out of, that were unexpected, and he really wanted to address that problem. And so he put a lot of provisions in here, and we went through lots of conversations with judges and attorneys and teachers and administrators about what to do here. And in the end, we didn't change a lot of law, but Senator Ashford wanted to encourage collaboration between all of the entities that we talked to. And I've heard really positive feedback about the provision that forces county attorneys to collaborate with the districts on their truancy policy. And I know this is happening. I know it's happening in Douglas County, and I know it's happening in other places. And Senator Ashford is probably the most excited about that out of anything that came out of LB 100. And the other thing that was a major change was at 20 days of absence, the schools can no longer count excused absences when they're calculating those 20 days. So regardless of why the child is out of school, if they're out of school for 20 days, we want the county attorney to know about it. And it puts more responsibility on the county attorney for responding to these cases and investigating these cases, but that's something that Senator Ashford felt pretty strongly about. And he also put together a truancy intervention task force, and we don't know the outcome of that so much yet, but they are going to get some more data from the Department of Education, and the schools are going to have to report more frequently and more consistently on truancies and suspensions and expulsions, and hopefully that will give us some guidance on what schools can do and what the juvenile justice system can do to keep these kids out of the system, address those truancies early on. The sealing of records was also a big part of LB 800. We wanted to give kids more, give everyone more consistent way to handle the sealing of records. Before, there was no way for children who were diverted from the system to have their arrest record sealed or whatever diversion record they had. And there was no direction on how children were supposed to respond to questions about these records. And so we put into statute some guidance on that. And once they've completed their diversion or their sentence or their rehabilitation, then they can petition the court to have these records sealed, and they don't have to respond that they've had this interaction with the juvenile justice system when they're asked on job applications or other kinds of applications. So we hope that'll be a really positive change for the youth of our state. In LB 800, there is this reporting requirement for the schools to report more frequently and more consistently about kids who are having problems and resulting in truancy or suspensions, expulsions, or behavioral problems in schools that require law enforcement to be contacted. Senator Ashford would really like to see more interaction and information sharing, and there are issues with confidentiality, with FERPA and HIPAA, and he's looking into all of that and really trying to come up with ways for all of you to be more collaborative. And I know that you all work together a lot, but he'd really like to encourage that. So that's kind of what he's looking at for the future, and what the committee will probably be looking at in the future. And with that, I'll open up for questions. I did want to say that we're having 2 hearings this fall on implementation of LB 800, this bill. One is going to be in Omaha on October 29th, and that'll be at the Civic Center, and it's at 9 a.m. And so the whole morning will be the Judiciary Committee hearing from all of you and other people about how the implementation of this bill is going. And then there's going to be another one, same subject, in Grand Island on October 9th, and that's a Tuesday. And that's also at 9 a.m. The afternoons of both of those hearings will be focused on the Office of Violence Prevention, which Senator Ashford is very involved with. And so he wants to hear about the programming that's going on through the grants that are distributed through the Office of Violence Prevention. Yes? Okay.
All right. I don't know what a civil citation program is. Neither does the county attorney's.
Okay. Well, it's a way to cite a juvenile without giving them a criminal record. So it would give some, they have to report to the Juvenile Assessment Center. That's how we've got the bill set up. But it's designed in the bill as a pilot project that Douglas County can do if they choose to, and they could. It's pretty broad in the bill, so they would have a chance to be creative with it. It's for non-violent offenses or minor misdemeanor offenses. Similar to diversion. It is? Maybe I meant November 9th. I did. I meant November 9th. Thank you. Should be a Tuesday. So please come and tell us. I know I've heard some rumblings of issues with the juvenile, sealing of juvenile records. I don't know specifically what the issues are, but I've heard that there are some judges that want to talk about that part of the bill. So please come or tell somebody and they can come and tell us, or contact me anytime, and Senator Ashford would be very interested to hear. I haven't gotten any data. Maybe we will at these hearings. It would be very interesting to hear. Maybe we can get something from the courts. The question was about the elimination of the 3-judge panel. If we have any data about how quickly those cases are being resolved under the new provisions, and if they're not doing what we intended them to do, will we think about changing them? Thanks, Judge.